Hey, please, Lordship. Kindly pass over the time.
This is actually the fourth bail application. No?
Before this court.
Huh. One was withdrawn, of course, the third one. Lordship has rejected it once, twice, I think. Lordship's rejection order is at page 34. He wants Passover for the time being.
Yes.
May I please, my lord? Basically, this is a revision against concurrent finding because I have been convicted by the two learned trial court below, and one is appellate court, my lord. In this matter, my lord, I am supposed to deposit 25% of the 5 lakhs, but I could not deposit the same
NI matter.
NI matter. The matter pertains to my lord NI, and this present appellant is, my lord, very
This is
severely
also
ill. He is on a regular dialysis.
the
But
respondent
the
side is
respondent
not
side
here.
is not present, my lord.
MJ Abedin and their names appears, but it might come.
They may come, my lord.
After some. No, no. I know.
Mr. Decker, earlier also you were granted time, and for the same reason you took time to deposit the 20% of the amount.
No, that is why I had already discussed with the respondent side.
Same
my lord.
prayer.
Yes, my lord.
Why should you consider?
My lord,
Because
one
at
last
your
support.
request, the court passed that order.
My lord, may I kindly consider
On the same
email.
condition, you have already proposed it that you sought time to
Yes.
apply the order. Right?
Yes, ma'am.
Now, the same ground, can it be extended?
No, but I have made request several times to my client, my lord. But
Then we'll
he
just
is-
vacate the stay order. We'll vacate the
Instead
stay
of
order
it-
because on your prayer, the court granted time
Yes, my
to
lord.
the petitioner to deposit. It was on the same ground petitioner proposed this court that since he is suffering medical ailment, he should be given time to deposit this amount.
Yeah.
Right? So that was in March.
Yes, my
We
lord.
are in end of July.
I don't feel that.
So tell us
My lord,
after
is
4 months, if Mr. Deka, if you are going to make the same prayer,
yes, my
we'll
lord.
consider to vacate the stay order.
No, my lord, can we do another thing, my lord? Let this matter come on another day. On that day, my lord, may dispose of this matter. Because personally,
We'll
I
pass
cannot.
whatever order. The matter is pending since 2019.
Yes, my lord.
You're taking the benefit of this, the suspension of the order of punishment.
Yes, my lord.
Since 2019, you have also not deposited the money. We'll
Yes.
consider your prayer only if you deposit the amount because this order is in force.
My lord, one last opportunity may be allowed. If I fail to make the payment until
Yes,
subsequent
ma'am.
date,
That can be recorded one last, and the respondent side is also not here. Let both the sides be here, and then Lordship will pass the order. Day after tomorrow, Lordship can fix it up.
my lord,
He'll
next
inform
week,
the
my-
respondent.
because this week I have some difficulty, my lord, personal difficulty. Let it come on next Monday, my lord. 1 week time.
And he should inform the respondent before.
Definitely, I will inform the respondent, my lord.
On the prayer of Mr. B. Dekal and counsel for the petitioner. Matter is adjourned for a week.
Lordship will fix a
The
date.
petitioner is yet to pay oblique deposit the fine of rupees 5,00,000,000 has been directed by the court earlier on 21/03/2024. List on 22nd. Failure on the part of the petitioner to deposit rupees 5,00,000,000 as directed by the court on 21/03/2024. Passed earlier in this proceeding. The court shall consider to vacate the stay or passed earlier on (13/03/2019). In this revision petition.
Deeply obliged, my lord.
Wait, please, your lord. This is a quashing
The
petition.
interim order of suspension.
The quashing petition, my lord. I have come seeking quashing of the charge sheet vis-a-vis the proceeding. In this matter, my lord, may I pray for some time, my lord, because I filed this particular case when the cognizance was taken and the copies of the statement was not with me at that particular point of time. Now, my lord, the record has come, my lord. I may be allowed to get a certified copy of the record so that I can fairly submit with regard to the factual aspect of this present case, my lord.
Otherwise, the ingredients of 366, 376.
376.
Mr. Das,
My lordship.
record of this proceeding was received, the court order proceeding was received by this court on 18th of January 2023.
My lordship.
And since then matter was listed on
My lord.
several occasions from 22nd March 2023.
My lordship, on the last occasion when the honorable court divulged into the factual aspect of this case, my lord, because my case was entirely on the basis of the charge
You go
sheet
to
as
the
well
records. We'll
as
hear
well
your
as the
submission.
FIR, my lord.
You go to the records. Make
I
your
have,
submission.
my lord, this certified, I have the copies of the charge sheet as well as the, my lord,
That's
FIR,
why I was saying the record is
Only
here
the
since
statement,
18th
my
of January 2023.
only this
Why
statement.
today you are seeking for certified copy?
On the last occasion, my lord, I was asked to, my lord, to get the copy and then to submit, my
It is
lord.
up
That
to
is why,
the
my lord.
petitioner, you know.
And,
The court
now,
is-
my
it is
lord,
not the up to the court.
because
It
the
is-
vacation
the
was
copy
there,
is
my
not been
lord.
received by you.
Because the vacation was there, because 161 I am not entitled to get at this particular point of time before compliance of 207 CRPC, my lord.
You go to the records and tell us, make your submission, we'll see.
My lord, today, my lord, my lord, let it come upon Thursday, my lord. Because, my lord, if the factual aspect is this, my lord,
Entire proceeding has been stayed,
my lordship.
right?
But
Since
in
December
spite of that, my lord, I have
2021.
been informed that, my lord, warrant has been issued against the accused, my lord. In spite of this stay, my lord. I can get the certified copies of the order, my lord, and place it, my lord. I have a good case of quashment, my lord, otherwise, because apparently from the FIR as well as charge sheet, my lord, 376 does not make out, my lord. This case was filed against, my lord, one other person. 3 persons have been named, my lord. Charge sheet has been submitted only against the accused person.
Yes, madam, did you go through the records?
No, Lordship, I have not,
Go
but
through it. We'll hear it on Thursday.
Lordship.
Deeply obliged. Till then, my lord, stay will be continuous.
Next,
On
Stay,
Thursday.
my lord.
19.
it will be
Deeply
there,
obliged.
but
Deeply
be
obliged.
prepared on Thursday.
On Thursday.
Yes.
Got it.
Thursday. Map is what. I'm happy. time now.
Oh,
Yes,
Lordship, with the consent of the other side, Lordship, due to the some personal difficulty of the conducting counsel, Lordship, let the matter be taken up next week.
anyway, there is no stay order in force. What do you have to say, ma'am?
Lordship, in fact, the other side is also not here. কি হবে করতেছে, sir? And
Listed after the
it's a complaint case again.
Yes.
Five.
May I please, your lordship? I'm for the respondent, lordship. The engaged counsel, Mr. Jadalam, is out of station, your lordship. Finally, matter be taken after 2 weeks, your lordship. The next matter, your lordship.
Hello, LCR received. Matter will be fixed for hearing.
Your lordship, 20% is not been deposited. Your lordship, no order has been passed for depositing 20%, your lordship.
That 20% is not also, they cannot claim as a matter of right. That they have to make out a case for that. The Honorable Apex Court also clarified that aspect.
The concurrent finding is there, your lordship, but your lordship, as the engaged counsel is not there, your lordship. After 2 weeks, may the kindly matter be fixed, your lordship.
The check was issued in the name of Lordship for NGO purpose. NGO was there. And now they have not made the NGO as an accused Lordship in terms of section 141A, clause A.
Not complied with.
Not 141A says Lordship, if company is there, that has to, that company has to make an accused. Because it was given for that purpose only, not as an individual capacity. Of course, the director and others will be in the as an accused, additional accused, but prime accused has to be the company.
But the finding of the court is that it was issued in the name of the deceased accused.
But in the evidence your lordship will find, he categorically said that it was given for the purpose of NGO. Both the another accused was there, he subsequently died. Both these persons came to the complainant for financial help for the NGO. So if it is a NGO for NGO, they could have they have to make the NGO as an accused, because if some properties are there, they can realize from that also.
But it was issued in the name of the deceased accused.
No, Lordship may kindly see the evidence of the complainant. Just one line I'm reading. Paragraph 3 of his paragraph 3, Lordship, his evidence on affidavit, that in the month of December 2013, the accused Nurul Haq and Dulu Kumar Soikia, since deceased, meet with some financial hardships, and so they approached me personally for financial assistance for their NGO. And in paragraph 4, last line also, the accused also informed me that the amount will be deducted from the account of the NGO. So they were acting on behalf of that NGO, if we assume the allegations to be true.
Come to page number 18. Read para 10.
Yes, we can. Yeah.
Yes, that amount was given to the NGO. They were the president and secretary.
Read it, please.
My whole case is that, Lordship, that amount was given to NGO. It was taken by the accused as well as Dulu Kumar Soikia. So at this stage, he cannot be solely.
Did you annex that exhibit 1?
No, that is not annexed, Lordship. That record are here. Signature of two persons are there in the check. And they signed on as president and secretary. Not in their individual capacity.
So this particular evidence clearly indicates that it is loan was given to the NGO
Hmm.
and the NGO has not been made a party.
Your Lordship, I'm not prepared today, Your Lordship. The
So,
brief is also not with me, Your
okay,
Lordship.
we'll consider it, but thing is this is very clear. But there are judgments against you. Though you are representing the NGO, the other partner has expired. The president has expired or secretary?
President expired.
So the judgments are against you.
But that if company is not made accused, then that part is there.
Look, even then, because both of you represented the NGO, and that amount was refunded on behalf of the NGO.
I will
There are
address it
specific
at the-
judgments.
I will address it at the time of hearing.
Your Lordship, matter be,
You cannot sark off your responsibility repaying the amount. Give us a date.
Any date next month, Lordship?
5th,
yes, Your Lordship.
5th of August.
For admission, Your Lordship, admission, you will have, Your Lordship.
Is submitted. Who is out of state?
Mr. Jed Alam, Your Lordship.
Counsel for the respondent. Jed Alam. Out of station for the medical treatment. List on 5th of August. 6th of August. 6th. For admission.
Obliged.
Obliged, Your Lordship.
Please, your lord. My lord, in both this matter, my lord, senior advocate A.K. Bhattacharya is preparing, my lord. He has some personal difficulty, my lord, today. Kindly some accommodation may be given. After 2 weeks, my lord.
When do
Case
you want
diary
Mr.
is here. Case diary is here. We will retain 2 weeks would be sufficient.
When do you want, Mr. Rao?
My lord.
Give us a date.
After 2 weeks. Even
Yeah, to Miss Ma. And this is what, after 2 weeks, so 29th of
Next
July.
week?
My
Mr.
lord,
Rao, it can be next week. Why 2 weeks?
or could it be, my lord,
24th.
29th or 30, my lord?
Retain করবো না?
29 or 30.
2 weeks retain করবো। 24th if we can try.
23rd
there
has
are-
some problem.
আচ্ছা,
25th?
I think
Thursday.
it's fine, my lord.
Madam, on 25th?
25th. Lordship will do 25th. of-
Obliged.
On behalf of Mr. A.K. Bhattacharya. Where is it? No, like it. The prayer of the council for the party. Let's go.
25th.
Obliged.
May I please, your lordship? Lordship, may I maybe pass over day, your lordship?
Why?
Lordship, I am appearing on behalf of SP Chaudhary, your lordship. He has just arrived from Silchar, your lordship.
Today is the first day after vacation. Perhaps people are not ready.
Exactly, lordship.
That cannot be.
Yes. This is for
It's
quashing
just
of the
like
charge sheet.
Yes, lord.
498A case. I think, yeah. The LCR is here, but I have not checked. I have not
Go through it.
examined. Lordship,
We'll have it on Thursday.
Thursday.
This Thursday.
Thursday. Peter one. Thursday.
This Thursday.
Nick.
18th.
Record may be called.
Yes.
Record may be called for.
Lordship will see your lordship's rejection order is at page 34. They threw the bags when the police caught them. And the ground that they take is not from their conscious possession, as well as other grounds.
Nothing recovered from us.
Scan copy of the records of special wooden bracket NDPS. Look at close case number 34/2023. Be called from special from Session Judge Karimganj. List on 8th of August. This is from Karimganj, so cannot get it immediately.
May I please, your lordship, can you madam will be adjourned for the day, lordship? The senior is out of station, lordship.
Number 9. PVA.
Well, interim order is not in force.
No.
What happened?
Hmm?
Since 1st of May 2024. Doesn't matter. Interim order is not in force.
Yes.
Earlier it was there,
Ah,
but since
it was
31st of May 2024, no interim.
not extended. So you're not an interim now.
So you can adjourn it. Monday next.
Next.
Monday next. Monday will be 22nd.
Yeah.
Obliged.
May I please, your lordship. Lordship, as per instruction, lordship, the search sheet already been submitted, lordship. As per instruction, lordship, search sheet already been submitted, lordship.
They have come against the, for bail cancellation.
Bail cancellation.
In which case, charge sheet has been submitted.
Lordship, Lokhipur PS case number 56/2023.
Whether the name of the respondents figured in the search sheet?
Lordship, just over phone, they inform us that search sheet already been submitted, but
The search sheet has been submitted against the name of the respondents or not?
lordship,
Your application was you are agreed because they are granted bail.
lordship,
Now search sheet has been submitted, whether the names of those accused persons mentioned in the FIR has been there or not.
lordship, we have to inform the court, lordship.
Okay, we'll have it on Thursday.
Lordship,
Get the instruction.
lordship.
What's your good name?
I am in lordship.
During the deliberation of the matter, Mr. Ayamin, counsel for the petitioner, submitted that search sheet in Lokhipur, PS case number 56/23 has already been submitted after investigation of the said case. List on 18th, enabling Mr. Ayamin, counsel to apprise the court as to whether the petitioner wants to proceed with this petition. It was filed in granting pre-arrest bail to the present respondents number 2 to 7. FIR name accused persons in the said Lukipur Blessings, the Consultant Church. And further. The names of those respondents number 2 to 7. Regarding the search sheet on. Listener, legislature.
Lordship, can it be Lordship 24, Lordship?
Why?
Lordship, it's from Lordship,
Over phone only will know.
Asa Lordship.
At least you can have it just. You want on 24th?
Lordship,
Okay, on 24th.
obliged.
Which one is that? No, sir, not here.
The names of the council or the petitioners have been reflected in the cause list. The petitioner remain unrepresented. Pardon.
Yeah, paper
Mrs.
respondent number
Rahul Learned Counsel for the petition. And Mr. K. Patri Lekha, K.R. Patri, counsel for the respondent number. List on 19.
Obliged.
In terms of the earlier order,
Did you deposit the amount or not?
yes, 50,000 already deposited.
When? When did you deposit?
Lordship,
When did you deposit the amount?
on 3 dates, Lordship,
In the
Yes,
month
ma'am.
of June,
June,
in the month of June,
In the
three day-
month
on
of
three-
June.
June.
on 3 occasions, yes, 50,000 paid,
How much she has deposited?
50,000.
Entire area amount.
Area amount for the minor daughter, it was 1,20,000. Now 70,000 is pending, and for his wife, for respondent number 2, it was 1,61,000 till
So
June.
because direction was given the payment of his daughter.
Daughter,
So
daughter 70,000
out-
now pending.
out of the area amount, Lordship, 50,000 has deposited.
Till June, it was 1,20,000.
but the direction of the court was to give the entire amount, entire area amount, Mr. Doctor. Who did not set the part of the area amount.
Actually, he would be able to
Yes.
deposit the rest of the
Did you
amount.
seek because that was the direction of the court,
Yes, Lordship.
which the petitioner has accepted. Did you take any leave? That you will deposit only 50,000 out of 1,20,000?
At that time.
So, अपना मर्जी से होगा क्या? Then,
See, within
under the order of the court,
within a
you
month,
cannot be like, not within a month. To pay it within, we'll consider only if you pay within 30th of July.
Lordship,
Mr. Doctor, not that way. This is the order of the court, which is still in force.
yes, Lordship.
You deposit it by 30th of July. Today is 15th, we will not consider it up.
Lordship, let it be another 15 days, Lordship.
That will be on a month. That cannot be. This is an order of 24th of May. Deposit in remaining amount by 30th of July.
So I have to take it.
The daughter belongs to you.
Yes.
Then it is your responsibility.
Lordship, he is admitting, Lordship, but
Then At
they
least
want to
who
pay
did not bother you
in
to pay the amount of any such maintenance to your wife at this stage,
wanted to.
right? Only directed to pay your minor daughter.
Yes,
Then.
he is
deposit it
agreeing,
by
but
30th
Lordship,
of July,
some.
not beyond that. You can consider up to 30th of July.
Lordship.
It is submitted by Mr. Datta, counsel appearing for the petitioner. That in compliance of the order dated 24/05/2024, petitioner has deposited only 70,000 of rupees 70,000 as area maintenance of his minor daughter. On which date you have deposited?
On which date?
Mr. Datta, on which date you have deposited? Which date?
Actually, wait.
That is-
June.
It is first date is 13th June. Thereafter 15 June, 6 June, 13 June, and 15 June. 3 days.
Total amount of 50,000. Third, sixth, and 13th.
6, 13, and 15, Lord.
June 2024. Which has been accepted by MSA Burua Council for the respond number 2. Ms. Burua appearing for respond number 2, however, submitted that. How much to pay? 50,000.
No, Lord. 7,000.
70,000
Now pending
area amount is yet to be deposited.
till June.
Up to June 2024 is out, it's yet to be deposited by the petitioner for the maintenance of their minor daughter. As per the direction of the court dated 24/05/2024, the petitioner shall deposit the remaining amount of 70,000 towards area maintenance of the minor daughter of the petitioner as well as respond number 2 on or before 31st July 2024. List on 6th August.
Obliged, Lordship.
Yes, Mr. Gupta.
Lordship, kindly this matter may be adjourned as the conducting council is out of station. Mr. K. Borua.
Next week, ma'am. Next week, anything?
Your Lordship may fix the date next week.
Yes, give us a date.
Lordship, next week, any.
Give us a date.
Date.
Hard, Mr. It does Gokul and Children Council assisted by Mr. P. Yeltsin.
24th of July.
On prayer of Ms. P. Das, Learned Counsel for the respondent number 2. The matter will be fixed on 25th of July, to which Mr. Das Gokul and Children Council have no objection. Prayer allowed, list accordingly.
Highly obliged.
Lordship, matter will be adjourned for the day on the lordships.
Hmm?
Conducting counsel, Mr. S. Das is annual today, lordship. So matter will be taken after a week, your lordship.
In spite of sending reminders to the learned session judge Dhubri relating to criminal records of criminal appeal number 14 of 2022, the same is yet to be received. A fresh reminder. Sir, out the sentence. Peruse the office note dated 11/07/2024. A fresh reminder to the learned session judge Dhubri for the scanned copy of criminal appeal number 14 of 2022. Have you given the number correctly? Have you given the number correctly?
Yes, lordship.
Show us the criminal appeal.
Lordship, record is not with me, your lordship. He's annual lordship. I may take instruction from you, lordship. I will give it to court master, lordship.
Criminal appeal number is 14/22.
That's why we're asking, because normally no such, once a reminder is sent, that is sufficient. Normally no
Yes,
court
yes.
will keep it pending because the High Court matter definitely said something is there, might be the number is wrong.
Mm.
Where is the order?
Order is at page 33. Page 33, Annexure 7.
It was disposed of by additional session judge.
It is, acha, not noticed that.
Not by the learned session judge.
Additional session judge Dhubri.
That was just to remind you. The additional session judge Dhubri for a scanned copy of the records of criminal appeal number 14/2022. That was dismissed on 06/01/2023. Additional session judge to bright bold for it. List on 13th of August.
Deeply obliged, Lordship.
That is Lordship.
Yes,
Lordship,
My lord, M. Bhattacharya, engaged counsel M. Bhattacharya, election another court. Kindly timing for this matter.
Lordship, we require some time to file affidavit. Some development took place in that matter, Lordship.
let the council consider.
Obliged.
125. 16 is a jail appeal. I think the amicus is yet to be appointed. But you can see the orders.
The appellant has referred this appeal from jail who is undergoing the sentences, undergoing the sentencing under section 376 IPC. Of rigorous imprisonment for 10 years with fine of rupees 20,000. In compliance of the judgment dated 07/12/2023, passed by learned additional session judge within bracket FTC-1 bracket close Margarita, District Tinsukia. In sessions case number 6060 within bracket small m of the 2013, arising out of Lekhapani Police Station case number 39 of the 2008. Will admit this appeal.
Lordship,
Admit call for the records and can
And
appoint.
that's we'll admit also, we'll ask someone to.
Acha.
Appeal be admitted. Call for the records of Sessions case number such and such. 60 M 2000 from the Court of Law Direction Session Judge within bracket FTC -1 Margaret. Whether Debosi Striker is attending the court now,
Devashi say yes, yes. She's
She's
coming.
attending?
Yes, yes. I'll inform her, she'll come. She's coming, Arun.
she is coming regularly.
Regularly.
Srimati Debosi Striker,
Okay.
because we are following that list.
Lordship.
Her name is in the top in the matter relating to single bench. Srimati Debosi Striker. I'm panel counsel of this court as a Micah Security. B. Engage in a Micah Security for the appellant. Accused appellant. Registry shall furnish. On receipt of the 11 records from the Land Additional Section Judge FTC Margarita, the registry shall prepare the paper book
Single bench, otherwise paper books are not
Not
prepared.
Cabinet
Not
program.
provided in
Under
High Court
that,
rules.
The registry shall provide the copy of the judgment and order dated 07/12/2023 passed by Land Session Judge in Sessions case number 60 M of 2013 to Miss Debosi Striker, counsel for the accused appellant. Amicus Curiae preparing for the list on. We'll give a date, otherwise we may not receive the records.
Lordship.
28th of August. For order.
17, Miss Khatuniya came to the court, but she had to urgently take her mother to the hospital. So she has prayed for another date, not today only.
Next week,
Lordship.
just. On the prayer of MS S. Khatuniya, list this matter on 24th.
Sir, Anjad Ahmed is there as an amicus. Anjad Ahmed.
No, he has filed this appeal, I believe. And
I is also there. But we don't have the copy. Jail appeal, we don't get copies actually.
As an amicus he filed or as a legal aid counsel?
Perhaps legal aid.
Because there is no order from the court appointing him as an amicus. Maybe he's a legal aid counsel.
Ha. Both Khatuniar and NJ Ahmed, they are legal aid counsels.
To name of the council, legal aid council for the, it is not legal aid council. I don't know. Let us see, just a minute. Sharma. Different number. Next. Do the name of the legal aid counsel for the appellant is reflected in cause list. But the petitioner, but the appellant remain unpresent. List on. August case to 24 December 24. Same date it will come.
Not 24th.
Yes.
Hmm.
Yes, ma'am.
Lordship, in this matter, the petitioner is the husband, Lordship, who has filed this petition for quashing of the order passed by the Honorable Family Court, Silchar, Lordship. And against that, Lordship, I also have filed one IA for interim maintenance, Lordship. Till the order of maintenance has been passed, Lordship, nothing has been paid to the respondent wife, Lordship. And she is also having one son who is a 5 and 6 years old, Lordship. And she is literally, that means unable to maintain herself as well as as her son because of non-payment and non-cooperation of the petitioner, Lordship.
Lordship, whatever instructions I have, Lordship, the petitioner is, I mean, petitioner of the criminal petition is paying maintenance, Lordship. On 5/7/2024 itself, Lordship, he has paid maintenance as per the court's order in execution case 16 of 2023, Lordship. And some other development also took place in this matter, Lordship.
When did you deposit amount?
Lordship,
How much amount you have deposited?
as per the instructions, Lordship, 5,000 has been deposited on 5/7/2024, Lordship.
Lordship, order is of 10,500.
Yes, Lordship. Lordship, the petitioner has lost his job even. He has been in a private school, Lordship. So some development has taken place, and as the senior on the other side has filed an interlocutory applications, Lordship. So I pray for some time, Lordship, to file an affidavit countering his interlocutory applications, Lordship.
Lordship, before that, Lordship, let them file. I have no objection to that, Lordship. But the payment, this is the third occasion till last 2 years, 3 years, Lordship. This is the third occasion he has paid.
Lordship.
If it is so, Lordship. Okay, let me.
Yes.
So let them take time. I have no objection. But before that, Lordship, they have to clear the area maintenance amount, whichever is due to the respondent, Lordship. This order may kindly be passed by your Lord.
Lordship, as this maintenance order passed by the Principal Judge Family Court is not stayed, Lordship. So at this moment, I mean, no adverse effect is putting on him, her, Lordship. So, Lordship, we are not praying for any interim relief at the moment. Lordship, let us file the affidavit in opposition, Lordship, and thereby dispose the matter, Lordship.
Lordship, may kindly note that the order was passed on, final order was passed on 26/9/23. And till July, Lordship, he has paid only 5,000 rupees since then.
Lordship, may I submit that by this time, during this time, Lordship, he has lost his job in a private school job that has
You are
also,
Mr.
and the Majapriya, Lord.
Not Mr. And a Mazur council appearing for the petitioner. And MSF, the unlearned official public prosecutor of the state. Also heard MSM Bachaji. Learned,
I am appearing for respond number 2, Lordship, private
also
response.
appearing for the response number 2. Learned. In a petition filed under section 125 CRPC by the response number 2. Against the petitioner. The learned principal judge, family court, Kachar Chalcha. In FC, in bracket, criminal, CRL 11. Bracket close, case number 37 of 2020. By an order dated 26/09/2023. Directed the petitioner to provide maintenance allowance to the respond number 2. The rate of rupees 7,500 per month for herself and rupees 3,000 per month for their minor son till attaining the age of majority with effect from the date of passing of the state order dated 26/09/2023. I agree with the said order of the learned principal judge family court dated 26/09/2023. The petitioner has preferred this criminal petition. Frame amongst others for setting aside the said order dated 26/09/2023. Noted above. Along with an interim prayer to suspend the said impugn judgment and order dated 26/09/2023 of learned principal judge family court, Kachar. The court on 12/12/2023, while issuing notice to the respondents, categorically observed that the interim prayer of the petitioner shall be considered only after appearance of the respondent number 2. The respondent number 2 has filed the connected IA being ICRL 490/2024 for payment of area maintenance of rupees 10,500.
And cost of proceedings also, Lordship, I have paid,
Payable to her
because she is unable to,
and rupees 30,000 for maintenance and of her as well as for minor son, and also cost of the proceeding. Payment petition. The interim priority petitioner, next, as the service of notice and the respondent is complete. List on. 20th of August.
2-0, Lordship.
Next, I have 40. 490. RMS M. Bhattacharjee, counsel appearing for the applicant and Mr. Patel, blood counsel for the opposite party of liquid. Issue notice returnable by 1st of August. As Mr. N.A. Mazhavia, council has accepted notice on behalf of the sole opposite party. No formal notice need be issued. List according. We consider the IA first. Let us
Lordship.
Obliged, Lordship.
Deeply obliged.
Yes.
May please your lordship. This appeal has been preferred against the judgment of acquittal, lordship. Lordship, what happened in this case, lordship, the respondent issued a check, an amount of rupees 5,60,000 in favor of the appellant, lordship, and this check was dishonored, lordship. Then I have filed the complaint petition, lordship, and that was, and in that petition, lordship, I have adduced 3 numbers of witnesses, lordship, but on the defense side, no witnesses were examined, and lordship, she was acquitted, lordship. On the ground that, lordship, I could not prove that the exhibit 1, that is that particular check was issued by the accused, lordship. Only in suggestion, in a suggestion column, lordship, when I was examined as a PW1, lordship, that was a one suggestion that accused did not know how to put his signature, lordship. Then, lordship, I have adduced the evidence of the bank manager, UCO Bank, lordship. He specifically stated that she can put signature, lordship, and her specific signature are lying in the bank, lordship. Still, lordship, she was acquitted, lordship, on the ground that I could not prove that that check was issued by her, lordship. Page 22, lordship, paragraph 7 of the judgment, lordship, that is important. Paragraph 7 and paragraph 8, lordship. Since she did not adduce any evidence, lordship, that she cannot put her signature, lordship. That There is no evidence, Lordship, on her part.
But ma'am, please come to page number 23.
Yes, Lordship.
It starts at page 8, para 22, paragraph 8.
Yes, Lordship.
Can you read?
That the complainant did not take any further step to cause bring on specific signature, Lordship. That is, but the Lana trial court has the discretionary power, Lordship. The court can also call for the specimen signature from the bank, Lordship, after
But
the
in the case
deposition.
of the complainant,
Yes, after deposition of PW3. PW3 deposition is clear, Lordship. And there is no evidence, only one line in the cross-examination of the PW1, Lordship, that it is not a fact that the Shakuntala Kodi did not know how to put a signature. Except that there is nothing, Lordship. Except that there is nothing, Lordship.
para 7 at page 22.
Para 7, Lordship. During cross-examination, the complainant admitted that he has not submitted any document
It should
in
be
the
she, I think so, not he. Anyway,
in this case to show that he had transferred money to the accused and so through bank. He denied the defense suggestion that the accused did not give any check to him. During cross-examination of the complainant, the defense suggestion was that the accused did not know how to put signature. This suggestion was denied by the complainant. This is the
another part.
this is only one
The
suggestion.
Other part is that it also failed to prove that the complainant has transferred some money to the accused and the other
Lordship,
person.
kindly see the findings, Lordship.
Mm.
Page 28. In view of the above discussion that the appreciation of evidence, it is held that the complainant has proved that the check exhibit 1 was dishonored due to insufficient fund in the account of the accused person.
Next speaker, Judge and counsel appearing for the petitioner. Sorry, appellant. This appeal by the appellant complainant is against the judgment in order dated 25/01/2024 passed by under additional chief judicial magistrate Kachar Chelchak in case number NI-106 of 2021, whereby the sole respondent was acquitted of the offense under section 138 of the NI Act. Holding that the complainant, i.e. the appellant, failed to prove the check amount involved in the case was issued by the accused person to him. It's a notice returnable by 6 weeks. Appellant shall take steps for service of notice on the sole respondent by registered post authority, providing it corrected at the requisite postal stamps within 2 days from today. Call for the records of case number NI-106 of 2021 from the Court of Learned Additional Chief Judicial Magistrate Kachar Silchar. That was disposed of on 25/01/2020.
Obliged.
May I please your lordship? Okay, 482 proceeding. My lord, before proceeding, I have to submit one submission, my lord. My lord, here I have submitted, after receiving the notice, as the notice was in the form of Ms. DV case number. I have stated everywhere as Ms. DV case number, but the case number is DV case number. The Ms. word is not. So, my lord, I think I have to file an additional affidavit to treat the same as one, my lord. My lord, because I have received the notice as Ms. DV case number, so out of sight and typographical error, we have typed it as Ms. DV case. Whereas the case is actually, my lord, DV case, the Ms. word is not there, my lord. The 113, my lord, is the notice, my lord. 113 is the notice in which we have received as Ms. DV. So out of sight, my lord, it went as Ms. DV, my lord. Actually, the matter, and even we have sent the rules that in the certified copy it was written, the Ms. word is not there, my lord. So, my lord, I have to file. The DV case number and everything is correct. Ms. word is there in the each and every paragraph, my lord, which is there. DV দেখা
আগতে মিল লিখে
যাচ্ছে।
Yes, we'll just allow the prayer because it's instead of Miss DB, it should be read as DB case number.
My lord, the domestic violence case, my lord, in the e-courts also, my lord, the nomenclature is Miss case within bracket domestic violence. So we refer it as DV case also. We refer it as Miss DV also. My lord, in Morigao, it is MRDV, miscellaneous registered DV. So it's the same thing, my lord. Today is fixed for admission hearing, my lord. And my lord, if she wants to correct, she has to amend the entire petition. It cannot be done by way of an affidavit. And that otherwise, my lord, her submission may be recorded that it is Miss DV and DV is same. I am also not objecting to that, my lord. And my lord, in the e-courts, my lord, in the nomenclature, my lord, I have checked just now, it's miscellaneous, Miss case within bracket domestic violence. It's as simple as that, my lord.
If my lord, I'm ready for argue. If my lord allows on that point, then I have to, for the knowledge of this honorable court, I have, before proceeding, I have started with the exact position.
Because, my lord,
Because as per my knowledge, my lord, it cannot, but my lord, if my lord agrees, then I have no objection. My lord, I am ready to argue the matter. For my lord's knowledge only, I have.
this
stated
court has been approached, my lord, under section 482, my lord, for quashing of the domestic violence case, my lord. There are various prayers, my lord, laid down in the DV case, my lord. Protection order is there, my lord. Residence order is there, my lord. Maintenance is there. Compensation orders are there, my lord. And entire petition, my lord, the 482 petition, my lord, based on facts, my lord. Facts has been disputed. Dispute of fact, my lord, cannot be there, my lord, under 482. That has to be in trial, my lord. So, my lord, this case, my lord, is there is no merit in the case, my lord, absolutely no merit. Fact being that they are disputing the facts. For that, my lord, evidence has to be laid, my lord. And I am pulled, the wife, my lord, I am not getting a single rupee as maintenance, my lord. I am pulled till High Court, my lord, under this 482. I have to appear here, my lord, bearing all the expenses. And my lord, the entire case, my lord, what is the ground for filing of this 482 for passing of the DV case, my lord? So many prayers are there, my lord.
My lord is hearing the matter, my lord. If my lord is hearing this matter, then I will.
So I am praying for a disposal today, my lord.
What MSRC Borough Council preparing for the petition. And Mr. A. Khan.
F. Khan.
Sorry, F. Khan. And Council A.
Respondent number 2.
Respondent number 2. Ms. Borough Council appearing for the petitioner. Submitted that inadvertently for the petitioner click that public prosecutor, additional public prosecutor respondent for Mr. F. Khan, right counsel for respondent. Ms. Burwal and counsel appearing for the petitioner submitted that in this petition she has inadvertently mentioned Ms. Amas within bracket DB bracket close case number 176 of 2023 pending before the Court of London Sub-Divisional Judicial SDJM record, SDJM number 2 Kamrup Metro Committee. Which was actually registered as DB case number 176 of 2020. The court by order dated 27/02/2024 call for a scanned copy of the records Said Miss DB case number 176 of 2023 Court of London SDJ. Number 2. Kamrup property. It has newly received by the it has been received by the registry. On perusal of the same, it is seen that the application of the respondent number 2 while under section 12, 18, 19, 20, 22 and 23 under the provisions of protection of women from domestic violence act 2005 before the Court of London Chief Judicial Magistrate Kamrup Metro Guwahati against the petitioners number 14 was registered as DB case number 176 of 20. That was transferred to London as DZM within bracket as Roman 2. For necessary consideration. Very notice was issued to represent petitioners on 31/10/2020. As such, the Miss DB MIS within bracket DB case number 176 of 2023 pending before London as DZM number 2 Kamrup Metro as DZM Sodor 2 agents. SDGM number 2 Kamrup Metro be read as DB case number 176 oblique 2023 instead of this DB case number 8. List tomorrow for admission.
My lord, I'm grateful, my lord.
May I please, my lord? My lord, I am appearing for respondent number 1, my lord. My lord, I am appearing for respondent number 1, my lord. My lord, I pray that this matter will be taken up in the next week, my lord. I have to receive some instruction, my lord.
Mr. H. Gupta, Learned Counsel, has entered appearance on behalf of the son number 1 and 2.
Only 1, my lord. 2 is the estate.
Mr. number 1. Praise for a short application. Privilege of counsel for the petitioner. Mr. Kulika, D. Kulika. You are A.K. Gupta. I have wrongly spelled it. A.K. Gupta. As the heard. Mr. Granted additional public prosecutor for the respondent. 23rd. List on 23rd.
Lordship,
Yes.
English Council, H.A. Ahmed's father was dead, Lordship. So he went to Bolpeta. So matter may be adjourned for. Devta.
It is submitted the bar that the land counsel for the petitioner, Mr. H. A. Ahmed, is under bereavement. Yes, when?
My lord, any day lawsuits convenient, my lord, since the LCR has come, my lord, in
August.
item number, next item, my lord.
In August.
So is it together,
Sometimes in
my lord,
August.
lordship fixed, my lord?
8th of August.
My lord, little bit later, my lord, because police আছে না? Little bit later, any day
Give us a
after,
date. Give us a
the
date.
lordship fix the matter after 15 August, my lord. By this time, 40 days will be over.
On 28th of August.
Yes, my lord.
And as agreed by the parties, placed on 20/08/2028 for admission.
My lord, in item 23, there is an interim order.
And 22 also interim, Lordship.
Interim আছে না?
Entry mode. Opt. I'll let the labor in court. Till then.
एक over.
Much of it.
24, 25.
Yes, Mr. Mahmood.
My lord, in this case, there are two cases. Parties are same. In one case, Abdul Mannan is the sole party, and another case, Abdul Mannan and his brothers are the petitioners. My lord, case is this, my lord, there is a long dispute between the two parties regarding a plot of cash land. Under compulsion, my lord, due to torture let loose by the lady, I had shifted my residence from that place, that is from Abhayapuri to Jogi Gopal. Now, in earlier occasion, my lord, she filed a case against me through her husband. That lordship may kindly see item case number 44524. Page 13 is the FIR, which is filed by the opposite party, page 13. Ma'am. Here, informant is Manjula Khatun, ma'am. Manjula Begum. So this Manjula Begum filed a case against me. I am an advocate of Abhayapuri court, my lord. And she tortures me like anything to capture the cash land which I is occupying. Then I had to leave that place forever because of her continuous torture. Then there was another case, my lord, which was filed by my wife. That lordship may kindly see page 23. In this case 23, my lord, this was lodged by my wife against this Manjula Begum and some of her relatives, including husband. And in that case, charge was filed. So, however, considering all these aspects, and the cases are pending
Yes,
between both the
in
parties,
this case,
there is a compromise.
number.
Well, there is a compromise between the two parties, and that compromise letter may be seen validated. Item number 4, case number 487, man. 487. That is page 28. So this is the situation. Now the parties have compromised among themselves, and they do not want to continue the case. In such a situation, my lord, our limited prayer would be that this honorable court may send this matter to the learned court below to consider the compromise arrived between the parties, because there are series of litigations between the parties.
In which case do you have arrived at compromise?
Yes, that lordship may kindly see
In,
criminal petition number 487/24, page 28. This Ismail Hussain is the husband of Bonjila Begum.
you are appearing for respondent number 2?
Lordship, yes, I'm for respondent number 2, item number 24.
Hmm. Charge sheet has been filed against which party?
Charge sheet has been filed in both the cases, madam. They filed the case. In that case, charge sheet is filed, that is page 18 of criminal petition number 445. And my wife filed FIR against them, that is also charge sheeted, that is page 23 of criminal petition number 445.
Lordship, I'm only here for item number 24. Criminal petition 487/20.
Couldn't we file an affidavit getting compromise? Because this is not a joint petition. If it had been a joint petition, then matter would have been.
No, this charge sheet has been filed under sections 341, 294, 506.
No, it is joint petition. Ismail Hussain and Abdul Mannan, both of them have put their signatures. Page 29 of criminal petition number 487.
Section 294 is not compoundable. Section 294 is not compoundable.
Compoundable, I think, with permission of the court, perhaps.
Not even permitted.
294 of sin.
294, it's not compoundable. Where is the other charge sheet?
That is page 23 of criminal petition number 445.
Beautiful B. Four 354 B, no? Report. For 448, 354, the charge sheet. 354 with permission of the court. 354 B. Not 354. Lakshmi question is. Share.
Again, 354B is not compoundable. In that cases, even if it is compromised, what will happen?
In some that's a level. Don't it, right?
Because charges against the petitioner in both the cases, one case is 294 is there non-contemptible, and other is 354B. Both are non-compoundable. Even there is an agreement, the magistrate will not able to act on.
Available or not.
With permission of the court. 354 no, 354 B. Section to section. 354 is only 354.
354B.
354 B section. You cannot equate 354 B with 354. Imprisonment of 3 years.
Yes, my lord. Anyway, it's
Maybe my lord, his case may be covered by Lakshmi Narayan's case. My lord. From
No,
section
but
26.
anything with the,
In some non-compoundable case, may be compromised.
that may be compromised, but when the
As per-
matter relates to, if you read the judgment,
Yes, Lakshmi
and
Narayan,
this matter relates to particularly
private dispute.
assault on
and-
women and nothing, particularly sexual offense, that cannot be,
Heinous offenses are not, my lord.
it has been considered.
Now,
That includes any offense on women.
that is of course, my lord. But whether, my lord, 354B, assault or use of criminal force for women. So whether that will, that may be examined, my lord, your Lakshmi.
354B will not come under, because will not be come under the provisions of the judgment of
482.
354 B divided.
in 294 will also not come. That kind of exemption probably may not be given by the court.
Judgment one is canceling.
Then let, day after tomorrow, my lord, I will bring the judgment.
Will if you bring through that, will be applicable for 294 and
Gyan Singh and Lakshmi Narayan
I
Sabho.
don't think so.
Gyan
Even
Singh
Lakshmi
2012.
Narayan case will not be there, not
My lord.
applicable. 294.
There is
252
other
B.
provision also, my lord, at the time of adducing evidence. Section may
That's
be,
why there has to be trial. At this time, we cannot, unless those things are proved, we cannot consider indecent criminal petition. That will be only on the basis of evidence before the trial court. Without there being an evidence, how can it be interfered at this stage?
day after tomorrow, let me satisfy your lordship.
Bring it, if you have anything like that.
Actually, I am a practicing lawyer, that is why I have some difficulty.
But thing is this, we don't know. Yes, next.
Kitty.
May I, please, may I allow to withdraw the case? My lord, in connection with this case, a criminal petition was filed before this honorable court. And accordingly, the criminal petition is allowed and directed to file a regular petition, bail petition before the trial court. And hence, I may allow to withdraw the case, my lord.
Your number? I don't know, man. 26. 26 bill, no? Ujjwala. Yeah. LCR is there,
Not pressing
that
this.
BF, he's not pressing his.
Send out.
Other matters are disposed of, I think.
Yes.
Hearing it as equivalent.
But Mr. S. You are making
Hearing it
counsel for
as
the
equivalent.
and Mr. Additional public prosecutor. For this matter. On instruction of the petitioner, Mr. S. You omit counsel and considered counsel is not pressing this petition. For him. This bill application. The petition was only the trial. Hence dismissed being not.
Publish.
Lordship, the LCR was called for and the appeal was admitted.
Where is the operational date 05/06/2025? 23/05/2023 as well as 05/06/2020. Issue reminder. Rana Judicial Magistrate First Class Kamruk Metro Guwahati for the case of for the records of CR case number 756/2017 put in bracket under section 138 of the NI disposed upon 29/06/2019 put in bracket Debasis Motunda EEBA as MAUMEER versus NR Construction and Srimati Kamrani PHAN DRA and PHAN. Typically, the case number under section of time of disposed of 29/06. Failure on the part of the Lanitime website. To furnish the records of say CR case number 756 of liquid products. On the next that fixed. Court shall consider the consequential order. Like the concerned magistrate is obstructive the adjudication of this matter which is pending for adjudication since August 2022. Placed on 19th of August. Published.
Here the appeal has already been admitted. I am pressing the 389 application for bail. We have taken steps on the informant as per the order passed by the Honorable Court. To my information, they have received.
POXO nahi? No. POXO, I don't have the service report of course, but I'll have to check. Deepak Naik is available. You have given it to registry. Acha. Kul thana.
Second point of
Bongaigaon.
the
Yes, yes, this is sentence final. This was only for 2 months.
My lord,
That
yes.
has been suspended.
Yes, yes.
So imprisonment is suspended and the records are here. But one thing is that notice from the informant. There is no information whether it has been served or neither the unserved ID card nor the report could come.
Nowadays, that is after division bench judgment not mandatory. My lord. Or else your lordship may appoint one amicus curiae also, if necessary, my lord, at all.
Public prosecutor can look into it.
Yes.
Sufficient. By order the 26/09/2023, this appeal was already admitted. It is seen that from the office note, it is seen the relevant records being sessions within bracket P2, bracket close, case number 214/2017. It was called for. Has also been received by the registry. In view of the above, sentence. By order dated 26/09/2023, fasting, the connected I identified C 907/2023. The sentence imposed upon the appellants by the impugned judgment and order dated 31/08/2023 has already been suspended. List this matter for hearing. And the month of on 3rd September. Lordship, as per earlier order, scanned copy of LCR was called for. LCR has not been issued yet.
Scan copy ke female अपन ना लेना voice copy original को चुप कर Service completed. Bill is bill is discuss to dispose. How you dispose? Appeal is already admitted, madam.
Here is the office note dated 22/04/2024. Though by order is a 06/12/2023. Records of Sessions case number 316/2018. State of Assam versus one Department Doctor to Pursuit Doctor, Chilsuman Doctor, Alliance City Doctor, Rinku Doctor, Alliance Control Doctor. Decided on the disposal of 04/2023 was called for from the Court of Learned Session Judge Every. The registry is yet to receive the record. Scan copy of the given. Record scan copy of the scan copy of records of such. Issue reminder for the said records. The learning session judge to break. Scan copy of the said record. List on 19th August. Next.
May I please, first you kindly produce the order dated 3/6/2024. Worship since 15/5/2024.
Yes, this is a POXO matter.
Mal.
Earlier, Mr. Borthakur appeared. And
Yeah.
Borthakur was supposed to obtain instruction.
আমার recondition নেই।
This is from Nalbari. Informant is from
Gograpar sir, Lordship, Nalbari. তোমারই পঠাচ্ছে কোথায়?
Bro,
My lord, let it come up day after tomorrow or
no,
still
listen, don't do that.
many
Note down
occasions.
note down the address of the informant and ask the Gograpur police station.
Yes. Indian. Village number 1. It just listen.
That is the address, please note it down and let us know.
Yes, yes.
We'll give you some time. Please don't.
Nice number.
Mr. and account counsel appearing for the petition. And you have plan additional documentation for the rest of the. Yes, we'll have it on 3830.
Mal.
Based on 38. And I'm looking for plan additional document procedure to advise the court. Regarding the status of separation, the respondent number 2, the informant, the relevant case.
Kindly date.
Will come on that. Don't worry, you will
Mass
offer an instruction.
Right, resource. Average service report on respondent number 2. We'll take fair system. No.
Where is the office notes? Dated 11/07/2024. Petitioner shall take first steps. For surface of petition, the respondent number 2 by Mr. Joshi Chetty Where is the FIR? The FIR was lost by the additional deputy commissioner. In his official capacity. So hardly there is any requirement. Public prosecutor can defend. There's no requirement.
Proceeding চলি আছে proceeding চলি আছে কিস্তি চলি আছে সাসপেন্ড করছে নাকি এই এমপি সাসপেন্ড হয়নি তো সাসপেন্ড কিসে লোন পেতে লাগলো ওকে হয় এটা কি হবে একটা চলে যেহেতু দিয়েছি College only is, no? The ground
It is seen that the Additional Deputy Commissioner Karbi Anglong Difu in charge of the NRC on 27/02/2017 submitted an application before the Superintendent of Police West Karbi Anglong Hamren requesting state authority to take legal action on forged documents submitted by some of the applicants during the NRC updation protest. Paid application of written petition of the ADC Karbi Anglong Difu in charge of NRC was forwarded to the officer in charge of Bochalangsu Police Station, West Karbi Anglong Hamren, by the Superintendent of Police Hamren. The same was considered to be an FIR in the process of the investigation was made. Considering the above, the response number 2, additional Deputy Commissioner in charge NRC Karbi Anglong Difu. আগতে পেরিল তো পিছনে being an official entity shall be represented by the public prosecutor of that state. According service on the respondents number on the page 1. Registry has already received the relevant reports of PRC number 450 of the 2019. The learned Judicial Minister First Class. Let's start being wrong. Place this matter for admission on resolution. Yes, give us a date. We'll get it. Because all are forged documents, forged birth certificates. Give us a date for admission. Any date you give us, we'll hear it on that day. Date.
June, July. 9th of August, no?
Not on 9th. We'll have it on 6th of August.
August.
May I please the Lordship, as per office note dated 19/4/24, Lordship. Neither unserved notice nor ID card has been received, Lordship. I cannot.
This is one.
POCSO case. Where is the
Lordship will give us 2-3 days time, we will file it.
Okay. from the office note. Dated 21/05/2024. It is seen that the registry has already received the relevant records from learned additional session judge Nagaon.
Copy now,
Also seen the order is the 13/05/2024. Passed earlier in this proceeding. The office note, the connected criminal appeal number 366/2023. Also seen the order. The respondent state shall file its objection on or before 29th, list on 31st.
Or positive.
Seven.
36. আমি objection দিছো নেকি?
No. Well, the state
আমি objection দিয়া নাই ন? কোনবা আছিল তো মানে মনটো নাই বাৰু। নাই, এইটো কোনবা লৈ গৈছে।
Mr.
Objection.
Botakur was there. Probably his mother was sick. That's why he
yeah.
was in hospital.
Yes.
So, my lord, your lordship would be pleased to see order dated 6/3/2024. Last chance was given, my lord.
আচ্ছা আচ্ছা।
But thereafter also 4 months passed, no affidavit, no objection has been filed, my lord.
I'll speak to Botakur. He must have prepared. I don't have the copy today.
My lord.
মই কথা পাতি দুদিন তিনদিনত।
No, my lord, it cannot, that type of privilege cannot be given, my lord. My client is in jail for about 249 days. They have not taken it seriously. Earlier also 2 occasions, they did not file objection. That is why your lordship passed order 6/3/2024. After last chance given, my lord, 4 months now, 4 months have come.
Understand there is a delay. I'll speak to Mr. Botakur. We'll file it within 2-3 days time, Lordship.
No, my lord, no
This-
further chance can be given. That is my submission before your lordship. Because it is the order passed by your lordship after considering the earlier orders.
Mr. Sheikh,
My lord,
when the matter was listed on 16/5/2024, time was taken by the counsel for the applicant. Thereafter, matter was listed on 29/5/2024. Again, time was taken on behalf of the applicant.
maybe, my lord, but regarding objection, my lord, this is the final order.
Later.
So, my lord, we can take time, but regarding objection, my lord, regarding objection, your lordship passed the order.
Order dated.
My lord, that type of indulgence cannot be given, my lord. That is my humble submission. Because earlier occasion also they did not. 2 occasions they take time. Your lordship considered and passed this order. We have taken time, my lord. That is your lordship allowed us.
সিহঁতেও মানে ফাইলবোৰ নকৰে মানে আমাৰ ডিভিজন বেঞ্চত
Orders passed in the connected criminal appeal. Reflect that. Time was granted to the public prosecutor to file its objection on behalf of the state relating to the bail prayer of the convicted accused appellant. Office notes. Dated 13/5/2024 reflects that the informant complainant, respondent number 2, has filed its objection against the prayer of bail to the accused appellant. The state is yet to file its objection. List on. (25/07/2024) for necessary consideration of this application.
Much. Obliged.
But time has been granted for.
25th. We'll consider your application.
That will be the.
We have seen already.
But that may be referred that order dated 6/3/2023, madam. The otherwise it will go on lapse.
If the state fails to file any objection in between during this period, court shall proceed to consider the matter without such objection of the state. Yes, next.
Obliged, madam.
May plead your lordship. 482 application, your lordship, for forcement of proceeding, your lordship. The petitioner before your lordship is a 75 years old lady, your lordship. The FIR.
They're informing me.
Very complete question. Service complete question. Next date of appearance as a 22. Appearance or date as a 22.
Mr. Gugoi, appear for respondent number 2.
Yeah, respondent two.
For the informant.
Well,
What is your stand?
what I would suggest is, my lord, considering the age, or she will grant me 1 week's time, my lord, let me have the instruction from the client, whether they would like to pursue or not. I raised this particular issue because there are two accused in the main FIR. One is the son-in-law, next is the present applicant. Leaving a 75-year-old lady, whether you would like to continue the case against her or not, my lord, in the trial case. That part, my lord, she will post it next week, my lord, let me have the instruction.
Your lordship, the next date of appearance is on 22nd, your lordship, of this month.
So,
So she will post it on that day itself. Because only the, my lord, one accused has come back, the other has not. Or on Friday, my lord. 19th.
You have to discuss with you about it.
Allegations are there. No? It's not. If the trial is on now, on a charge filling mode. Charge filling is around. Charge filling on a cognizance is not. Huh? Cognizance is there. And the charge filling I would give a try there instead of washing. So Japan by then we can not. I'm brother-in-law or mother-in-law? My brother-in-law. Feeling was a line. This time of.
Read the search sheet.
We are reading.
You
It's
are
there,
reading.
it's next.
Any materials?
In fact, against the mother-in-law,
No, because she is the old lady, because that's why the matter did not proceed. She was not arrested. See the reason?
one thing is there, the misunderstanding was created
There
between.
was a misunderstanding. There was a village meeting. In that
meeting.
meeting, that few rooms, rented rooms were allotted to her. She is occupying the, earlier she left the house, the informant, the complainant, right? Thereafter she returned, and while she was arranging to have electrical
Installer.
connection, that time the mother-in-law and the brother-in-law protested.
Yes, while trying to install a electricity connection, yes, they
And
protested.
this FIR was lodged. Now, whether the electrical connection was installed or not. That you don't know.
As per my instruction, Your Lordship, now the lady is residing in that house, Your Lordship, and the mother-in-law has moved out.
Now the
Friday, probably the guy.
Lordship, kindly peruse Annexure A, Your Lordship, page 30. This is the Jamabandi, Your Lordship.
see, she is the daughter-in-law, your daughter-in-law.
Yes, Your Lordship.
She doesn't have any children. Whether she is entitled for your property or not.
But the property has already been transferred in her name, Your Lordship. Kindly
Has been
peruse.
registered.
Yes, Your Lordship, page
Land has
33.
been registered.
There's a Jamabandi, Your Lordship, page 33, Your Lordship. 33, 34. Korobi Hoikya Koৰৰ নামত ইমান so and so দাগ নম্বৰ পাতা আৰু দাঁত মান হেৰি কৰা হ'ল। And now she is residing in that plot of land and the mother-in-law has moved out, in fact, Your Lordship.
During the charge framing, they can argue
Yeah,
to
they
get
can argue
discharged.
this. What is
This quashing, of course, is little in a pre-nascent stage.
The mother-in-law is not.
No, the land has been allotted,
Yes,
right?
sir.
The thing is this, maybe the dispute is regard to because she had to return to her paternal house because she was not allowed to live in her matrimonial home after the death of her husband. Thereafter, there was, as per the, of course, the charge sheet.
Now she is saying that she is staying in that place. He can get instruction on that, no?
Your Lordship, kindly peruse the FIR, Your Lordship, page 16, 15 and 16, Your Lordship. No offense has been made out as per the FIR.
The ingredients of 498A, that mental cruelty will come. No physical. Oh, okay. There is a delay also in lodging the Ejahar, but then she is saying that after she went to her mother's place, she fell ill. Bueno, বেমাৰ পৰিলে না? Compromise কৰিব পাৰিব। Let him take instruction. There might be some possibility of compromise and all.
Definitely, but they should
Yes.
fight.
Allegations are not severe as such, and
Mr. Gogoi?
On Friday?
It appears that land has been
Yes, sir.
registered her name now. After the death of her husband, her name has been incorporated.
Friday কৰিলো।
Or my lord, considering her age, her appearance, my lord, in the trial case, that may be dispensed of, my lord. Not that, my lord, because she is 75-year-old, the trial cannot be, my lord, initiated against. That cannot be a ground. Only when required, my lord, she may appear. Otherwise, daily, on each date, she may not appear. That protection may be given.
She is bedridden, she is not in a position. Medical বিলাক দিয়া নাই না, medical বিলাক দিয়া নাই।
Friday কৰি দিলে হ'ল। He
Please come to page number 32.
Yes, Your Lordship.
The total land in Doug number 530.
Yes, Your Lordship.
It was only 4 kotha, 21 lesser. So 4 kotha, 01 lesser.
Yes, your lordship.
right?
Yes, your
And you
lordship.
read the remark column at page 32. Where from 1 bigha, 1 kotha? Oh, acha, ठीक है. Because in 530 there was only 3 kothas, 14 lashes,
Yes, your lordship.
and 1766 there was only 7 lashes.
Yes, your lordship.
So altogether 4 kothas, 1 lesson.
Yes, your lordship.
And if you read that entire remark, they have carved out 1766, tag number 1766 from 530,
Yes, your lordship.
right?
Yes, your lordship.
Then, so in 1766, name of
Srimati.
the petitioner and name of her son was there.
Yes, your lordship.
Then come to page 33. The name of the petitioner was already there at 530.
Yes, your lordship.
Name of the son of the petitioner was not there at 530. Now come to the second part. Order number 1, Hukum number Act.
Yes, your lordship.
Kindly read it.
Hukum number 1.
Kindly read it. What
Yes.
is the total area?
Yes, your lordship.
Read.
Sakra Bikhoyar.
0 bigha, 0 kotha, 0 lecha.
So what is the land with her?
Hmm.
0 bigha, 0 kotha, 0 lesa.
No land.
No land.
But
There is no bath. That's the order.
yes.
Name of the daughter-in-law is there. The name of the widow daughter-in-law is there, no doubt.
Yes,
But with regard to what land? 0 bigha, 0 kotha, 0 lesa.
No, page 34, your lordship.
Kindly read 34.
And this is 530.
এক কথা 11 লচা মাটি শ্ৰীমতী কৰবী শইকীয়া কোঁৱৰৰ নামত 2255
Where
নং
is that land? Where is that land in 1766? Only 7 lesas were there.
7 lechas with it.
Yes, your lordship.
So where from 1 bigha, 1 kotha, or 1 kotha, 11 lesas will come?
Hukum 1, page 34, your lordship.
So
But then the area
there was
doesn't.
no
tell.
land at 1 kotha, 11 lesser. At 1766. There was only 7 lechas.
There's something more to be seen, I think.
Already you have sold land of tag number 530.
Daughter-in-law sold person.
You see, everything was sold by
Yes,
you.
your lordship, daughter-in-law has sold some land, your lordship, as per my
Therefore-
instruction.
How? That instruction is illegal, but this is wrong because there is no land to sell. From her doubt, she had only 0 bigha, 0 kotha, 0 lesser. It itself indicates something mischievous act. Nothing else. If you're not willing to part with your widow daughter-in-law, don't know.
But as per my instruction, the daughter-in-law has sold some portion of her land, your
No
lordship.
further instruction Mr. Gogoi is supposed to take.
Yes, your lordship.
I think the first page there is another Dag number 443, 543.
543, they named the land was
I
only
think
with
Huh.
1766.
Yes. Once.
1766, these are the 2 pages. You see on the second page, 32.
There 1 katha 4 lechas come.
There 1 kotha, 18 lesses were there.
Uh-huh. Huh?
530 had 1 kotha, 1 bigha, 1 kotha, 4 lesses.
Huh.
And 1766 had 1 kotha, 18 lesses. The page number 31.
31.
Now page number 32, those are the orders long back. That is in 2000, right, or 2001. Whereas in the order passed by the circle officer in the year 2019, the daughter-in-law had 0 bigha, 0 kotha, 0 lessons in 1766. There was hardly any land.
In 530, but
Not in 530.
But
No.
in
Come to page number 33.
in 530, I think, 0 kotha 0 nega,
No,
but
not in 530.
1766,
it's 1 katha 11 lasa.
no, 1766 to 1 kotha 11 lecha asalte nai. Only 7 lochas আছে there. কিন্তু পিছত বিক্ৰী কৰি এইটোত সোমাই দিলে।
এইটোত চেঞ্জ হৈ থাকে না
I
বিক্ৰী
don't
কৰাৰ
know দেই।
পিছত।
এনেকে বিক্ৰী কৰি এটা ডাকত সোমাই দিম।
This is a copy of Jama Bandi, no?
ভিক্টিমৰ নাম কি? কৰবী। সেইটো মই সেইটো চাইছো। 530 ডাঙৰ 0 বিঘা 0 কঠা 3 লেচা। শ্ৰীমতী কৰবী শইকীয়া।
See, in the order of the circle officer, order number 1, page 33. The order was of 29th of June 2019.
Yes.
That relates to Doug number 1766. Her name was included with regard to land of 170 bigha 0 kotha 0 lesa.
Yes, hello.
There is another order down below, you can see. That was also an order of 29th of June 2019.
Yes.
Name of the informant of the arrest. Again, 0 bigha 0 kotha. This is with regard to Doug number 530.
530.
In both the Dougs, he had 0 bigha 0 kotha. 0
Nothing.
lesa. So,
Page 34, you'll see Hukum number 1.
when there was no land, how can her name be included?
But by 21 order, she was allotted 1 katha 11 lecha.
Where from?
Where from? This is what is creating problem. And 1766 Doug. So,
There was no land at 1766.
no. 1766 perhaps some land was
Maybe.
included here later. Okay. Let him get the instruction note, you will see. Perhaps. Egg, egg.
Something is not clear, madam.
Very confusing. 21 edition can have it. Itu budi boli. Busa. Yenga budi by 21.
Yes, Mr. Gogoi. Not. Your case.
21 or 8 go fine.
Tell us.
So on Friday, madam, please.
Friday.
Yes.
It will be on Friday.
No, probably milli ase kiba. Touch. Friday.
Declare every council for the purchase list on Friday.
Oblige yellows.
I have a question for him. But official note 15/6/24 says there notice was issued, but ADF not issued. So service await for servicing. And scan copy of the also not received.
Where is the acquisition dated 15/6/2024? Await sir report of the respondent number, sole respondent. Registry is yet to receive the relevant scanned copy of records of CR case number 44/2019 from the Lanet MFC Bongaigaon. Petitioner is allowed to take fresh steps in the steps for service of notice on the sole respondent by register procedure, providing its correct and proper address within 2 days from today. Issue reminder. Damage. Judicial Magistrate First Class, North Salmara, Puri. The scanned copy of records of CR case number 44/2019. Okay. List on. August 21.
Leave petition. Accused person was acquitted in an NI case on the ground that there is no presumption, what is it called?
Heard Mr. B.K. Bhagwati, Learned Counsel appearing for the petition. Being agreed with the judgment and order dated 06/02/2024 passed by Learned Judicial Magistrate Nalbari in NI Act case number 126/2018, acquitting the accused person, I, the sole respondent, herein from the offense under section 138 of the NI Act 1981. The complainant / informant as petitioner as applicant / petitioner has filed this application seeking special leave to appeal against the said acquittal order dated 06/02/2024 noted above. Issue notice returnable by 6 weeks. Applicant shall take steps for service of notice on the sole respondent by register post within 2 days from today. By register post, providing its correct and proper address. List according.
May it please your lordship, my lord, the I-98 is before your lordship, my lord.
But LCR has not come, I think. LCR is yet to be received now.
My lord, because I am inside the jail for more than 7 months. Because I have surrendered on the day of judgment. Your lordship may peruse the judgment where the medical witness, medical evidence says that there was nothing inside there. At page, my lord, your lordship will find in the criminal appeal, PW5 MO has stated that there was injury was not detected, evidence of struggle not detected, evidence of stain not detected.
But this is a POXO matter without service of notice.
My
to
lord,
the
we have
L1.
taken Dusty service, they have refused to take. My lord, then we have sent it to the police. We have filed an affidavit. On 19/4/24, affidavit filed by Dusty service upon the respondent number 2. On 22/24, notice issued upon respondent number 2 OC of the Pondal Bazaar. Bhawalimukh, sorry, my lord, of the Bhawalimukh, OC of the Bhawalimukh police station.
Perhaps
Not
that
Mr.
report.
PK
from
and
OC.
counsel for the petitioner. NMS. As Zahan, non additional public prosecutor for the state. Where is the affidavit?
Affidavit dated. You know?
Filed by the appellant.
Para
Filed on
4.
behalf of the appellant.
Para 4.
Filed on 27/02/2024.
Para 4 and 5.
Stating that the authorities in the Bhawalimukh police station refused to receive the notice from the appellant as well as the respondent number 2 who to refuse the receive the notice in spite of the direction given by the court for service of notice in the respondent number 2 by justice service. The appellant hearing, the convicted accused
For 5 years, my lord. Maximum punishment was 5 years. Page 81.
under section 354 Odin Bekete IPC reduced section 10 of the POCSO Act. Petitioner is allowed to take first steps in submission of respondent number 2 by registered positary, providing its correct and proprietary circumstances within 2 days from today. For the appellant लिखेगा, petitioner ने लिखेगा. For the appellant is also allowed to take steps on the respondent number 2 through the Office of the Public Prosecutor, Guwahati High Court, Guwahati. Copies of this memo of appeal shall be served on the Office of the Public Prosecutor, Guwahati High Court, Guwahati, in 2 days from today, obtaining necessary acknowledgement in that regard. The
Madam.
Office of the Public Prosecutor, Guwahati High Court shall do the needful for service of notice on the respondent number 2. Where is the FIR?
The FIR is at page, my lord. FIR, page 19. Relevant page 21.
To the respondent number 2, in the address provided in the FIR at page 19 to the Horlumuk Police Station. Concerned authority of Horlumuk Police Station. What? List on fifth of August. The subject to taking steps on the respondents. Number two is directed. Nalagi, list on.
I mean, objection is.
Yes.
Yes, my lord, NCR has been received.
Our objection is also on record.
We have received the objection, my lord.
ये की पॉक्सो नहीं
No,
अच्छा 302 oh ambiguous अरे ये disappeared हाँ 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 आप Roman 302
no,
वो NDPS हाँ
41 Robert.
I need to follow.
Mr. Chaudhary, time will not permit today.
Yes, my lord. And my lord, any other date as pleased by this
What's
court?
the date? Next week? Monday,
My lord, next,
Tuesday,
my next Friday, if possible, my lord. Will,
not on Friday.
yeah, next Friday, my lord. Next week, Friday, my lord.
Next week
Next
Friday
week, Friday, not on Friday, not on the motion days. We'll have it on either Tuesday or Thursday.
Thursday, my lord.
Thursday?
Thursday.
25th
On the prayer of the council for the parties list on 25th July.
And DPW.
On 28/6/2024, the brief has been taken back by the appellant. My lord. My name has been shown here, my lord. Finally, I want to withdraw my name. And I have given the NOC also.
Do you have the,
Yes, yes, yes.
to submit it by filing an affidavit, then we can consider, because there are a lot of criminal appeal, as you know.
I think registry they should make an application
Yes, you have to submit an application before the registry.
Okay.
Intimating that the person concerned has, or the appellant has taken away the brief. Right?
Yes, yes, my lord.
Just a minute.
registry के लिए बोला था ठीक है अपन नाम पे लिखा है कितने नियम था क्या हाँ registry की बोल oh वो बेसी है
On the prayer of Mr. Burakohan, at council. List after 10 days or list
Hello.
after 2 weeks?
2 weeks. Obliged.
I think there is a delay of
Lordship, delay of 50 days, Lordship, in filing the corresponding criminal division petition, Lordship.
zero to nail. You have punishment. 324.
Okay, good day.
Condonation of delays between the court and the lordship and condone it if your lordship desires. And it's 324 matter.
What is the ground shown?
Lordship, the certified copy was obtained, Lordship, on 22/9/23, and thereafter, Lordship, the applicant had contacted the local lawyer
and he advised to contact MSP Chakraborty. Lordship, and the conducting counsel was seriously ill and she had to undergo one surgery, Lordship. Lordship, thereafter, she had instructed her colleague to file in the month of February, Lordship. Lordship, there was a delay, Lordship. Para 10, para 8 and 8 and 10. Delay.
এখানে application paper 389
Surgery, due to surgery, she could not prepare them.
Reasons are there in paragraph 8, 9 and 10.
What's your good name
He can't.
for the applicant? And I'm Shah Jahan, Learned Counsel appearing for the state. Additional by judgment dated 18/09/2023, first in criminal appeal number 22/2022. Learned Session Judge Jodhalpuri. Upheld the sentence passed by Learned Chief Judicial Magistrate Jodhalpuri dated 29/09/2022 in their PRC case number 1298/2019. Arising out of GR case number 927/2019. Convicting the applicant with simple imprisonment for 3 months with fine of rupees 5,000 under section 324 IPC, and in default of fine, simple imprisonment for another month. Division case number 2. No, judgment dated 18/9/2023, Learned Session Judge in criminal appeal number 2022 of 2000. Agree with the same. The convicted accused have filed this revision petition with a delay of 50 days.
Lordship, 50 days.
50 days. The applicant slash appellant submitted that he could obtain the certified copy of the order 18/9/2023 of the Learned Session Judge Chhattisgarh on 9/11/2023 after applying on 21/9/2023 and thereafter contacted his counsel who suddenly had to undergo medical treatment and had undergone surgery. And as such, there was delay in filing the connected revision petition against the said order. This has been an order to the 18/9/2023 of the Learned Session Judge. The applicant could furnish sufficient reason for the delay in preparing connected revision petition. After hearing the current consulted parties, delay of 50 days in preparing the connected revision petition against the judgment and order it is such and such caused by Learned Session Judge in criminal appeal number such and such hereby condoned. Accordingly, this interrogation stands allowed. Registry shall register and number the connected criminal revision petition prepared by the applicant as appellant and list the matter for admission.
No, my lord, IF for my lord, condonation of delay of 41 days in preferring the my lord connected criminal revision petition, my lord.
May I please, your lordship? Lordship, I am appearing on behalf of respondent number 2, lordship. Lordship, today I am going to file the objection on the IA, but unable to trace him, so it
Furnish him a
is
copy?
signed, lordship.
Now itself.
Yes.
Administrator as per counsel appearing for the petition. Sorry, applicant. My name is S. Rehan. In addition to the prosecutor for the respondent number 1. Also heard MS M. Sharma, not counsel for the respondent number 2. Next week.
Next week, man. I have a simple prayer, my lord. Another matter is pending between the same parties, my lord, concerning the same point of law, my lord. In that case also, my lord, delay is there, my lord, on 41 days, my lord. Can that matter also be tagged together? In that case also, my lord, she is also appearing, my lord. Same matter, my lord, between the same parties, my lord.
List on.
List on, my lord, along with my lord, IA number 176, my lord.
29. Along with IA.
176 in criminal revision petition number 1258.
176 only 2024. In criminal revision, has it been registered?
Yes, ma'am.
That has been registered.
Yes, ma'am.
But there is a case of delay.
Delay, my lord.
That in that matter, delay has been condoned.
No, my lord, no. In that case also, my lord, she has appeared there.
Then why it has been registered? It is only the criminal revision has not been registered.
No, my lord.
Okay.
My lord,
Finding-
I, my lord, 176 of sir.
202.
Much of it.
Obliged.
Maybe, this is notice was issued, my lord, and we have taken steps accordingly. But as per office note, my lord, 14/6/24. Notice, it was shown that notice was not served, my lord. But still it was received.
The revision of your judgment. Quashing of the proceeding.
Official note,
Where is the
14/6.
office note? Dated 14/6/2024. Petitioner is allowed to also heard, also heard MS Jahandar, additional public prosecutor. For response number 1. Petitioner is allowed to take press steps on the response number 2. Providing his correct and proper registered to the party within 2 days from today. List of the 6 weeks on the activity explained. Next slide.
In this case, my lord, we have received the case diary. The case diary was called for, my lord. It can be disposed of at the admission, my lord, at the order stage itself, I think.
POCSO case.